Okay. Are we going? Are we going? Yes. Looks like we're okay. This is technology. Technology. So I wanted to jump on here really quick and do another hot take. Um, hot take is just where I see something in the news that I think is interesting, and I want to just jump on here and kind of talk about what it means. And what I have right now is from, could I be wrong? Absolutely. Am I wrong a lot? Probably. But I think that this actually could be one of, if not the first, COVID-19 wedding professional lawsuits filed in the United States. This is a lawsuit filed by the mother of a bride against the venue, which is a hotel, to get deposit money back because COVID-19 allegedly in the complaint caused the wedding to not go forward. So as as far as I can tell, this is one of the first, if not the first, lawsuits filed with this set of facts. So I wanted to kind of go through this because I think that this contract that is the basis of this lawsuit is kind of typical in some ways. In some ways, it's not typical. So I think it's interesting. And, a lot of people are talking about Supreme Court is hearing oral arguments and stuff like that. And it's like their Super Bowl. This is my Super Bowl, talking about this stuff for you guys. Anyway, okay. So we're starting off here. The contract between the mother of the bride and the hotel, the wedding venue. And again, the mother is Melinda Gillis. The hotel is the Mayo Hotel, and this is in Oklahoma, Tulsa, Oklahoma. All right. April 17th, 2019, mother, wedding venue, signed the contract. The contract is for, typical reception. It's for 300 guests. There's a $10,000 minimum for food and beverages. There is a $2,000 rental fee. So the bare minimum of the contract itself is about $12,000 to $13,000. Okay. Again, this is April 17th of 2019 that this contract is signed. Okay. The contract lays out there to be 5 payments over the course of the year, with the wedding to take place on March 21st of 2020. Are you following me? So contract is signed April 17th of 2019 for an event, for a wedding reception to take place March 21st, 2020, which couldn't be the worst timing ever in the history of timing a wedding. Okay. So the mother of the bride, Melinda, the plaintiff in this case, makes the 4 payments, okay, throughout the course of the year, which amounts to be somewhere around $13,000. Okay, so there's 5 payments that are due before the event. The 5th and final minimum payment is due on March 16th. Okay, so the complaint, the petition here, the lawsuit, essentially says, okay, look, let's go through this. We got March 14th, Donald Trump issues a state of emergency for the country. Okay, fact number 1. Fact number 2, Oklahoma, the state in which this event is supposed to take place, they have their own state of emergency. Okay, then on March 16th, and again, March 16th of 2020 is the date that the final payment, minimum payment, is due. On March 16th, this is 5 days before the wedding. 5 days before the wedding, the mayor of Tulsa issues another state of emergency. And the state of emergency that the mayor of Tulsa makes is that events can't have more than 50 people. There has to be social distancing, XYZ. Okay. So you got March 14th, federal government, state of emergency. March 15th, the state of Oklahoma. Okay. State of emergency. March 16th, Tulsa, state of emergency. Now, the mother of the bride is like, okay, look, I got old people coming. We're not going to be able to have 300 people because it's at this point now illegal. So we want to essentially trigger our force majeure clause that is in this contract. The force majeure clause that is in this contract, and it just so happens that we have the language of this force majeure contract. So this one, typical force majeure contracts, typical ones. Now, again, this is a good example of the fact that not every force majeure clause is written the same way, but many force majeure clauses provide a certain amount of time for you to work together until after the force majeure event is terminated. This one does not. Let's digest this. Let's read this together. This is the force majeure clause of this contract that is the basis of this litigation. The performance of this contract is subject to acts of God, government authority, disaster, or other emergencies, any of which make it illegal or impossible for either party to perform its obligations. It is provided that this contract may be terminated for any one or more of such reasons by written notice from one party to the other without liability. So the contract can be terminated due to a force majeure event without liability to the other party. Okay? Very interesting force majeure clause for a hotel to have. Anyway, so the mother of the bride says, look, I'm not giving you this fifth payment. I'm invoking the force majeure event. I am terminating this event under my rights or within my rights under this force majeure clause. And I want my money back. And the reason why I'm asking for my money back is because of this clause here that says without liability. Now, what that is actually going to mean will be probably determined sometime down the road, okay? So that's what the mother says on March 16th. What does the hotel have to say about it? Well, the hotel says, sorry, Charlie. And not only sorry, Charlie, but you owe me money. We were perfectly willing and able to go forward with this event, and you canceled it 5 days before the event, and you owe us $5,000. So not only are we keeping your 13 grand that you're asking for, we want 5 more from you. As a matter of fact, it looks like there was a bit of communication between the parties before, and attached to the, first of all, I'm not here to, besmirch any other attorney. But typically when you file a lawsuit, you want to redact certain things like social security numbers and people's telephone numbers. So that I got cell phone numbers, I got addresses, I can go to people's houses based on what's been filed in here, which is typically not good. In Georgia, you get in trouble for that. Anyway, so the hotel responds with, we've got bigger concerns right now than suing you for what you owe us. Okay? So the big X on that. Now, we don't just get to a lawsuit at that point. We don't just get to the courthouse steps at that point. So the mother of the bride, who's $13,000 in the hole, wants it back because you can't have the wedding because there's a state of emergency, looks back into this contract and sees that there is an arbitration clause that the parties will resolve any controversy, claim, or dispute arising out of the contract before one arbitrator conducted in accordance with the rules of the American Arbitration Association. Nothing strange about that. What is strange, and I should have an arbitration podcast coming up. I'm not quite sure. I don't remember whether or not that's coming out next week or the week after that. It doesn't matter. I'm going to have a podcast completely dedicated to my opinions about whether or not arbitration is a good idea for your contracts as a wedding professional. But at any rate, arbitration is included in this contract. So the president, not the president. Maybe it is the president. No, the president of the LLC, which I guess owns the hotel. Maybe the president of the hotel says, no, let me go back. Okay, so there's an arbitration clause. The mother says, look, we have a controversy at this point. I'm invoking the arbitration clause, and I want to go forward, not with a lawsuit, but with arbitration. That's not strange. What is strange is that the president of the LLC or the hotel, I can't determine which, says, we don't have time to arbitrate. We don't have time to deal with your stuff. Essentially, many would argue, and I think that many would agree, is a waiver of the arbitration provision. Why the hell put arbitration in your contract if you're just going to waive it right offhand? Okay, that's what's strange to me. Like, arbitration is in this thing in order to keep you out of court. But you're telling them, I don't have time to deal with your mess. I'm not arbitrating this matter. That's probably a bad move because it's going to make this situation for this hotel public when it would have been private. Anyway, whatever. Okay, so no arbitration then. So that they're not giving any money back. So that leaves the mother of the bride. Their only option is to file the lawsuit, and that's where we have this now in the District Court of Tulsa in Oklahoma. Now, what are they asking the court for? That's the question. There's essentially what's called a cause of action. There's two cause of actions in this petition. The first cause of action is breach of contract. Okay, why isn't it force majeure? Well, essentially, it's breach of contract because they're saying a force majeure event has been triggered under the notice provision of the force majeure clause, where we're terminating the contract, and because the contract says without liability, you got to give me my money back. And if you don't do that, you have breached the contract because that's what you're supposed to do. That's the obligations under this contract. So that's count number one. Count number two is, Your Honor, if that's not good enough for you, if you don't want to do that, then what we're seeking is what's called declaratory judgment. That's the second cause of action. Hang on. Let me fix that. Declaratory judgment. Declaratory judgment. Man, I'm running out of steam. Marco Rubio. Declaratory judgment is a remedy under the law that's not money. It's essentially you're asking the judge to read the contract and make the decision for us. So in this instance, the second cause of action being declaratory judgment is saying, Your Honor, can you please figure out the meaning of without liability? Can you please figure out the meaning of force majeure? Can you please determine whether or not force majeure has been triggered? And if the judge says, okay, I'm going to do that, then it allows the parties to move on from there. So the main thing a couple of things to take from this and the hot takes of this lawsuit is this, that number one, hey, everybody's saying hi to each other. Anyway, what's going on, guys? So, I missed my train of thought here. Anyway, now, what's probably going to end up happening, the hot take of this, hopefully the hot take is that the Mayo Hotel is going to try to settle this before their answer is due. This is like hot off the press. Like I'm not quite sure what the statutory requirement of responding to litigation is, responding to lawsuits. What's up, y'all? It's Cheryl and Shay and Aaron. What's up? Oh, and Matt. Hey, everybody except me. Anyway, this is going to make no sense on YouTube when it gets replayed. But anyway, thank y'all for watching, I guess. But and subscribe to YouTube. Anyway, so probably what's going to this, because this has just happened. What's probably going to happen is that if they're smart, if Mayo Hotel, and I keep wanting to say Mayo Clinic, if Mayo Hotel is smart, they're going to settle this case. Because why would they? There is absolutely no way that for a hotel that is having that's having weddings with 300 people, there's no way that $13,000 can be is enough to fight about. It's enough to withstand the scrutiny of people being like, man, like it's a state of emergency, and you wanted people to show up. You wanted old people to show up among 300 other people and coughing into the green beans. That's ridiculous. So if they're acting with, appropriate customer relations, that they're acting as good business people, they're hopefully going to settle this before the answer is due. The answer to the litigation is due. So that's my prediction about what's going to happen with this particular case. It's probably going to settle. But if it doesn't, I will definitely be keeping an eye out, because there's a couple of issues that are really interesting with this. Number one being the issue surrounding force majeure in this contract. Secondly, did the hotel waive the right to arbitrate the dispute by essentially rejecting arbitration? And also whether or not the judge is going to allow the case to go forward or issue declaratory relief that they're asking for. So there's a lot of good, cool things. I mean, cool things to me. I mean, what am I doing over here? Nothing. I'm in quarantine. So this is cool to me. So a lot of cool things to watch out for. I'm hoping that if there is an answer, then I'll do another hot take, and we can talk about where the case will go from there. Everything is public record, so I can print it, talk about it when it happens. So I hope that you found this somewhat, I don't know, informative. Anyway, I mean, it's for the record books. I mean, like, there aren't that many of these, and I think that this might be the first one, but I suspect that it will not be the last one, and we're going to get a whole bunch of new case law on force majeure clauses and pandemics. And that's going to be my hot take for this, and I'm going to be out of here. So thanks, everybody, for watching this. Again, if you want to see it again, go to my YouTube channel, and you can see the whole thing. For those that just jumped on here, you can watch it on YouTube a little bit later. And with that, we'll peace out on y'all.